All right, we'll go on the record in the matter of the People versus Daryl Dwayne Bowman. This is file number 2401. This case occurred before this was the 46th Circuit Court, so we do not have a standard 46th Circuit Court case number. If I could have counsel put your appearances on, starting with the prosecutor, please.
Your Honor, Ryan Saylor on behalf of the people.
Good afternoon, Your Honor. Erin Bartels from Sato on behalf of Daryl Bowman, who appears in person today to my left.
Thank you. And the record should reflect the defendant is present here in the courtroom today. This is a date and time set for resentencing pursuant to the change in the law based on case law and new statutory provision regarding the sentencing of juvenile life sentences without parole. I am in receipt of an updated pre-sentence report that was prepared by the Department of Corrections. I've had a chance to review that, as well as the stipulation that was entered into between the prosecution and the defense regarding the imposition of a term of year sentence. I'm also in receipt of numerous letters from family. I did have a chance to read all of those letters. I took quite a bit of time to read all of those letters. There were numerous submitted, and so I appreciate all those. I did have a chance to review those prior to today's hearing. Aside from that, Mr. Bowman, have you had an opportunity to go through that updated report with your attorney?
Yes, I have.
Okay. And counsel, are there any additions, deletions, or corrections that need to be made to the PSI?
Your Honor, I spoke with the prosecutor and the agent here today. There are a couple places throughout the report that list the charges as count 2. Those will just be updated as to count 1 because he's being resentenced on count 1. Those are on page 1 and 2 of the updated pre-sentence report, but I've already run them by the prosecutor and the agent here today. And other than that, no additions, corrections, or deletions.
All right.
Thank you.
Mr. Ziegler, is that a correct statement?
It is, Your Honor.
Okay. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Pursuant to statute, the victims do have an opportunity to address the court today. Do you have any victims that wish to address the court?
Yes, Your Honor. I believe that the decedent's brother would like to address the court.
Okay, sir, you would like to come forward, please. Now let's ask you to come right to this podium there where that red light is.
Thank you, Your Honor, for
Yes.
doing this, and I thank everybody that's involved.
Can you tell me your name just for the record?
My name is Roger Allen Kronk.
Thank you. What is it that you would like to say today, sir?
Just wanted to show you a few pictures. This is my mom and dad. We had 8 children in our family. Ronnie was a pretty awesome guy. He knew what he was going to do his whole life. You know, he was one of those kids that got all A's in schools, was in all the sports. Everybody loved him. He was coming home that day to give his girl a ring. And he was meeting with the guy that owns a pharmacy up there. The guy that owned the pharmacy up there was helping get him through college. He would have started a family. He would have had the business taken over. He'd be same age as Mr. Bowman. They were both the same age, with just days apart, I think, on birthdays. This was our family picture with my dad and 7 boys. I'm the baby. This was Ronald. This was just before he went into college. Looking at this girl, Mary. All these people just, their life just went to hell because of this man and George Bowman, you know. This was Ronnie with me. He was an awesome brother. He would stand out in the yard. Him and my brother would hang on his arms and he'd twirl us around. This was Ron right before it happened. Ronald was beaten, cut, and stabbed so bad, my father couldn't identify him. My dad said, I don't know if that's my son or not. He was only identified because There were so many boys in our family. My mom put our names in our underwear. That's how it was handled. It's the only way he could identify him. And then he also saw a scar on his knee that he got during football. I don't know if I know the entire truth. 57 years ago, I was 9 years old, but I remember my dad coming home from that day, 2 priests on his arms. When the priest got out of the state police car, I knew something wasn't right. My dad was bawling. Never seen my dad cry ever then. That was the first and last time. I heard my mom scream, and they made all of us boys go outside and sit outside. And we knew that was Ronnie, that was dead. From what I understand, Mr. Bowman has never taken the responsibility of that. He was there. He said he wasn't there. His mom said he wasn't there. She testified in court saying that he was with her. Long time ago, I put this in God's hands. I said, you know what, Daryl Bowman, I forgive you, but I will never forget you. I can't forget it. You can just imagine having to identify your child, but you can't identify your child because they're beaten so bad and cut so bad. I never forgot laying in the casket. They had to put so much makeup on his neck because his neck was cut so bad. And at 19 years old, you know what? You can pick up a rifle. I did at 17. I picked up a rifle and defended my country. So was it that different 57 years ago? I don't think so. People were in Vietnam at that time, younger than 19. You knew what you were doing. But in 1987, he was 37 years old. He knew what the hell he was doing then. He helped organize a prison break. 2 guys, Daryl and one guy, they didn't do anything, of course, but one guy that helped get out, he had murdered a Michigan State trooper. That guy was all over the Midwest. He robbed 5 banks. And in Mississippi, he robbed the wrong bank and came up against the wrong sheriff. That was the end of him. But at 37 years old, Daryl should know what's going on. He should be held responsible for that. He should be responsible for the 5 banks that were robbed if he helped that person get out. From what I understand, he's the one that got the keys. They got up in the air conditioning ducts, called a taxi, got out of there. But he should be responsible for that at 37 years old. Your Honor, you have the right to keep Daryl in until he meets his 60th year in prison. You also have the right to give him 5 more years after that for the escape from the Michigan State Prison. All I ask you to do is do what your heart tells you, be professional, and do your best. That's all I want you to do. If Daryl gets out, it's by God's word, and I have no problem with it. This is the last time I'll speak about it, last time I'll think about it. After this, I'll just destroy everything and we'll be done with it. So, and that's it. Thank you for listening to me. We appreciate it. My family appreciates it. I'm the only brother left. I promised my mom and dad I would never stop until it was time. And today is the day. So, amen. Thank you, sir.
Mr. Ziegler, anything you want to say on behalf of people today?
Yes, sir. Your Honor, this case pains me a great deal because I feel like I have no choice but to agree to a term of years sentence. The Michigan Supreme Court, without any individualized consideration, retroactively threw out hundreds of life without parole sentences across the state. Families like Mr. Kronk's have had their peace of mind ripped away from them by this ruling. They were told at the time that it was life without parole they were going to be in for the rest of their lives. And the Michigan Supreme Court has decided that's not the case anymore. And I can't change that Supreme Court decision, Your Honor. Their ruling was a rebuttable presumption exists now that the defendant cannot be sentenced to life without parole, and I can only overcome that presumption by clear and convincing evidence. While a layperson might not truly understand the mountain that creates for the prosecutor to climb, in this case and in other cases across the state, I certainly do, and I'm sure the court certainly does. I cannot agree with the Supreme Court's ruling because it forces me to try and explain to the victim's family something like this murder was not the most egregious murder in the grand scheme of things. How do you tell someone that? How do you tell someone that their brother being beaten to death with a tire iron on the side of the road for $3.55 is not an egregious murder? You just can't, Your Honor. To the victim's family, this is the most egregious, the most despicable, most inhumane thing they could ever envision. But to you and I, Your Honor, and to other attorneys who deal with this stuff on a regular basis, it's probably not the most shocking or gruesome murder we've dealt with, even in the last 8 years, even just in this small rural county in Michigan. And to overcome a presumption by clear and convincing evidence, the crime would have to be exceptionally brutal, would have had to involve multiple victims, or would have had to have been a part of some organized criminal activity or some other significant aggravating factors. And unfortunately, this murder just wasn't those things, Your Honor. The defendant had no criminal history prior to this murder, not even as a juvenile. The defendant has no criminal history after this murder, although it's worth noting, and Mr. Kronk did note, that he escaped from prison in 1987, and he voluntarily turned himself in a few weeks later. Had he not already been subject to a life without parole sentence, it may have been a prosecution and it may have been a consecutive sentence. But aside from that escape, he's had a grand total of 2 other infractions in prison in 57 years. Those being disobeying a direct order in 1995 and possessing stolen property in 2004. And that's it. And while 3 infractions, again, sounds serious to a layperson, you and I know that most prisoners rack up misconduct tickets at a rate of 2 or 3 a year on average, and some of them significantly more than that. I can't say his conduct before the offense overcomes the presumption. There's nothing there. I can't say his conduct during the offense, as horrible as it was, overcomes the presumption. I can't say his conduct after the offense, although it was not perfect, overcomes the presumption. I cannot in good faith come before this court and tell you that this defendant or that this murder were especially deserving of punishment above and beyond all other murders. We've just sentenced a murderer in Kalkaska a month or 2 ago, Your Honor, who I felt was far more deserving of a life without parole sentence in my mind. And that was not even an option on the table for that offender. With all of that said, Your Honor, if a life without parole sentence is not on the table for this defendant, the next best thing is the maximum term of years that the statute allows. That would be 40 to 60 years. And that is what the defense and I have agreed to, and that is what I asked the court to do today. I hope the court and the family understands. If I thought I had any reasonable argument to overcome the presumption in this case, I would be up here making it. But I can only ask the court today to follow the rules that have been laid out by the Supreme Court and to give this defendant the maximum sentence allowed by those rules. Thank you, Your Honor.
All right, thank you. Counsel, if you and your client can come up to the podium, please.
Yes, Your Honor. And Mr. Bowen does have a statement he wishes to address the court as well.
Okay. I'll have you allocate first once he's
Okay.
there.
Thank you. Your Honor, I would like to start by acknowledging the tragic and senseless loss of life in this case. All of these cases are first-degree murder cases, and there is nothing, all murder is heinous, all murder is egregious, and these cases, and in these cases, we are focused on the punishment. And both the United States Supreme Court and our state Supreme Court have found that it is cruel or unusual to mandatorily sentence juveniles and adolescents to life without parole. And so I know that I submitted a sentencing memo for your honor's review, and I won't belabor that now. And as the prosecution pointed out, Mr. Bowman can only be resentenced, anyone can only be resentenced to life without parole if they are incapable of rehabilitation. And Mr. Bowman has proven and shown in 56 years that he has the capacity to rehabilitate if he is not already rehabilitated. I know I submitted to the court dozens of work evaluations, letters of recognition and recommendation from Michigan Department of Corrections staff. And as someone who only does these types of cases, candidly, I don't see that. And so I agree. We are asking the court to impose the maximum amount of years under the statute, 40 to 60, and we ask that you do that today. But I know that Mr. Bowman has prepared something in advance, and I'll turn it to him.
Thank you, Mr. Bowman.
Yes, Your Honor. I want to take full responsibility for the murder of Ronald Crump on November the 22nd, 1968. I don't know if Mr. Ronald's family is here in court today, and I'm sorry for the pain and suffering that caused your family and your loved ones. No number of apologies or whatever could never change. Well, Mr. Crump, I wish I could change for Mr. Crump. Mr. Crump was 19 years old, could have been married with children or grandchildren. His life was ahead of him, and I robbed him of that. And I'm sorry. I'm so sorry. I'd also like to apologize to County of Kalkaska for the fear, pain I caused the residents of Kalkaska County around the state. Everyone was afraid of their safety, and though they took away from you, and then I took away from you. I'm sorry. I wish there was something I could do to ease your pain. I wish I was able to go back and make better choices. "56 years ago, the only thing I could do is show kindness and show that I am a better person, even today. There's not a day that goes by that I haven't thought about the suffering I've caused the family, and I'm so sorry. Thank you, Your Honor."
All right, thank you. As I indicated at the beginning of the hearing, I did read through the updated pre-sentence report. I read through all the materials that were provided surrounding the original sentencing, including the original pre-sentence report that contained all the details of the murder in this case, the details of your life at that time. The updated report, of course, has given me a lot of information about what's gone on in the interim. I read through the memorandum that was submitted by your attorney, and as I again stated, I did read through all the letters that were submitted by the family of Mr. Cronk. I'm not going to say a lot about the details of the crime here. Mr. Cronk discussed it. The prosecutor alluded to it. I don't think there's a lot that needs to be said about the heinous nature of the crime itself, and really just the senseless and needless loss of life here that occurred for really no reason at all. And I don't think that needs any additional commentary. I think what's important here today, number one, for me, is to acknowledge all of the relatives that are here in the courtroom today. The letters were very impactful to me. They were very heartfelt letters. And those letters and your presence here today, I think really speaks to the impact that Ron had in the short time that he was here and that he was with you. And I think it's a really touching tribute to him and his memory that all of you made the effort to come here today. And I think that even though 56 years have gone by, the impact of your actions that day, Mr. Bowman, it's clear that they're still felt and that they're still very real to the family and something that they have lived with over all of these years and always will live with. I think it's unfortunate that all of you are here today having to relive this because of a change in the law that now says that a sentence that you thought that you could all count on was wrong and shouldn't be imposed. And I thought it was particularly striking, Mr. Cronk, about your statement that you're here to carry through with the promise that you made to your parents, what you were going to do. Yet the state of Michigan isn't carrying through with its promise to you and to your family. And I think that's unfortunate. It's a change in the law that has really taken the discretion out of my hands as a judge in terms of what I can order. The statute speaks in terms of the court shall and the court must. And as a court of law, I am compelled to follow the law. I can't make it up, regardless of whether I agree with it personally or not. It's a change that determined that it's unconstitutional to sentence a juvenile to life without parole, that it's cruel and unusual. I think that's a change that doesn't take into account the fact that you all have been living a life of a sentence without parole. No one's ever going to let you out of the prison that you've all been in, regardless of any changes in the law. The way that perhaps Mr. Bowman may be someday released. It's a change that was decided by judges and legislators that never have to sit in the chair that I'm sitting in and look at all of you folks and listen to what you had to say and read what you had to say and see the true impact of this kind of a change in the law. That's something that they don't have to do. They make that decision in a different forum and they don't have to look all of you in the eye the way that I do and the way that the prosecutor had to do. But again, it's a change that's been made. It's a change that as a judge I'm bound to follow. And it's a change that doesn't leave me with much choice other than to impose the maximum possible sentence that I can impose under the restrictions that I'm now under. And that sentence is a sentence of 40 to 60 years. If I had the authority, Mr. Cronk, to impose additional time, believe me, I would do it. I don't have that authority. Again, the statute speaks in terms of the court must and the court shall. And so it is the sentence of the court, Mr. Bowman, that you serve 40 to 60 years in the Michigan Department of Corrections. You do have credit for 20,701 days served. To the extent that there are any fines or costs that remain that were imposed at the time of the original sentence, the court would preserve those. You do have the ability to seek an appeal of this sentence. And counsel, we're going to provide you with some acknowledgement of those appellate rights. You can have Mr. Bowman now receive those rights.
Thank you, Judge. Mr. Bowen has stated and initials of the advice of appellate right.
Mr. Ziegler, anything else that we need to address to the record?
No, Your Honor, thank you.
Mr. Bowman, you are remanded to the custody of the state at this time. The court's going to take a short recess. I do have another hearing at 2 o'clock, and I'm going to take a short break before I take that up.
Thank you, Your Honor.
All right. Well, I guess that went what you'd call smooth.
Okay, we've got two other council that are connecting in, so just 1 second, please. Okay, I think we have everybody connected. Oh, Australia just left.
And others.
Okay, we'll go on the record. This is Nellis versus Munson, file number 2113787. If I could have council put your appearances on, please.
John Elliott, Your Honor, on behalf of Mr. Nellis.
James Elliott on behalf of Mr. Nellis.
Nick Arteev on behalf of the Kalkaska defendants.
And Karen Beach on behalf of defendant Munson.
All right, thank you. We're on the record today, continuation of some motion hearings that we started in June. These were a couple motions from that we did not have time for at that time. So today we have Kalkaska, their motion for summary disposition pursuant to C7 and C10. And then we have a motion for partial summary disposition regarding the damages claim for related to stroke care and rehabilitation. I have had a chance to review all the submissions by the parties, the briefs, as well as the exhibits that were attached to those briefs and the deposition testimony. I'd like to start with the motion for summary disposition under C7 and C10. And so, Mr. Arteev, if you would like to proceed with any oral argument that you'd like to present as to that motion.
All right, thank you, Your Honor. I understand you're very familiar with this case based on the last hearing. You've gone through, the briefing and deposition testimony, so I'll try and keep my arguments brief just to save time for any questions or rebuttal. As this court mentioned, this is our summary disposition motion pursuant to 2.116 C7 C10, specifically based on plaintiff's failure to satisfy mandatory statutory procedural requirements applicable to medical malpractice actions. As this court's familiar with, this is a case based on a fall that plaintiff Mr. Nellis sustained while he was being unloaded from an ambulance at Kalkaska Memorial Health Center. Mr. Nellis was a stroke patient being transported to a long-term care center to continue rehabilitation for his stroke. He had right side paralysis. He was unable to speak. And as this court may remember too, our clients, we filed a summary disposition motion at the onset of this case based on governmental immunity essentially for Kalkaska, and that motion was partially granted as to most of the counts. The only remaining count was the ordinary negligence claim, and the court allowed that to continue under the hospital exception under MCL 600-14074. So essentially, Your Honor, we've been continuing that light in the discovery, but as discovery is now concluded and we've reached kind of that end point, based on the allegations and the testimony that's been provided in this case, I think it's evident that plaintiffs' claims sound in medical malpractice rather than ordinary negligence. The Supreme Court in Bryan v. Oak Point, they do set out the standard for what is a medical malpractice case, not a ordinary negligence case. First, there needs to be a professional relationship that exists, and that's not in dispute as far as I can tell from the plaintiffs, that there was a professional relationship between the defendants. So the only remaining issue is the second prong, which is whether the claim raises questions of medical judgment beyond the realm of common knowledge and experience. And here, Your Honor, I think we've pointed out in our briefing that there's substantial testimony in this case that indicates that certainly the medical judgment was implemented by the defendants in this case when they were unloading Mr. Nellis from the stretcher. In particular, the manner in which Mr. Nellis was supposed to be unloaded from the stretcher, according to the allegations, really Mr. Nellis' medical condition should have been in consideration with how to do that in a quote unquote proper manner or a non-negligent manner. This is supported by the deposition testimony. Plaintiff first, when they deposed our clients, they spent extensive time questioning them about their own training background and experience in understanding how to load and unload patients from an ambulance using that particular stretcher that was used in this case. We went through the instruction manual of the striker cot that was used to transport Mr. Nellis, and there was extensive questioning about whether there was compliance with that particular, how to use that particular cot. And again, as I mentioned earlier, the medical condition of Mr. Nellis did affect the manner in which he was supposed to be unloaded from the ambulance. Notably, each defendant testified that they knew Mr. Nellis had a stroke when they were transporting him, and there was testimony regarding the manner or technique that they needed to strap him into the stretcher, and ultimately the allegations speak to the manner in which Mr. Nellis was unloaded from the ambulance, which does go towards medical judgment of the EMT and paramedic, who are the defendants in this case. Specifically, the allegations are regarding the amount of people that needed to handle the stretcher, and also, the need to kind of lower the stretcher before allowing, only one person or unlatching from the ambulance. And that's to accommodate for the patient's weight and right-sided kind of lean that he had in this case. So basically, Your Honor, we're looking at whether the medical judgment was implemented, and we've cited to extensive case law in our briefing that suggests that the transport of a patient does implement medical judgment in these types of cases. They are not ordinary negligence cases. We've cited the binding case law precedent and in these types of cases. Notably, the Rogalski case, we've cited to that one. That's a Michigan Supreme Court case, basically where a technician was alleged to be negligent when they were assisting a patient moving out of a wheelchair onto an examination table. The patient fell during that transport, and the Supreme Court ultimately confirmed that that was a medical malpractice case because the medical judgment was implemented in the manner and technique of moving the patient. Similarly, the Troll case that we cite to is another Supreme Court case, but that does talk about the failure to assist and supervise, failure to provide adequate number of nurses to assist the patient while they're in the hospital. It's similar to the allegations made in this case, where they're saying that there needed to be two people on the stretcher to properly transport a patient like Mr. Nellis. And then we cite to published Court of Appeals cases in the Wiley v. Henry Ford Cottage Hospital case and the Sturgis Bank case. Both also found in the transport of patient in a medical setting did implement medical judgment as well, and to unpublished cases, which obviously are not binding on this court, but do provide some factual similarities to this particular case. And I think what's important in this particular brief, Your Honor, is that we need to make sure that the standard is what's being analyzed is proper. I think based on reading the plaintiff's response briefs, I think they're essentially arguing that basically that we don't need medical judgment knowledge or expert testimony to essentially explain to a jury that someone shouldn't fall when they're being transported from an ambulance. But again, as we point out in our briefing, that's just not the right standard here in this case. That's a strict liability standard that's not applicable to medical malpractice cases or ordinary negligence cases. Similarly, they kind of talk about how it's easy to explain to a jury how to load and unload a patient. You don't need an expert to do that. But again, that's not the right standard. The correct standard is analyzing essentially whether the medical judgment was implemented by the defendants in this case. And I think based on the binding case law that we've cited to and the testimony, the extensive testimony that's been provided by the defendants, I think it's evident that certainly medical judgment was implemented in loading and unloading Mr. Nellis from the ambulance in this case. Finally, Your Honor, I think, I don't think plaintiffs disputed this in their response, but if this court does find that this was a medical malpractice case, then the case really does need to be dismissed on the merits. The plaintiffs would be required to submit an affidavit of merit. They'd also be required to submit a notice of intent 182 days prior to filing a complaint. Case law does indicate that essentially a med mal case only commences once a notice of intent is filed. And at this point, since the notice of intent was not sent to us, basically that implements the statute of limitations in this case, which expired a couple of years ago. And then just lastly, Your Honor, I think we mentioned this in our brief, just as a matter of housekeeping. I think Mr. Aylesworth, Kent Aylesworth, is named still as an individual defendant in this case. I don't think there's a question that he was not involved with the transport of this patient at all. The only allegations that were made against him in that third amended complaint were essentially based on a alleged, misrepresentation or discussion that he had with Miss Nellis. And those claims have been dismissed so far, so I don't think there's really any basis to keep him as an individually named defendant in this case. And with that, Your Honor, I just ask for court to grant our motion and dismiss this case in its entirety with prejudice. Thank you.
All right, thank you. And I know that the plaintiffs have objected to Munson joining the motion, but I did want Ms. Beach, was there any argument as to the merits that you wanted to make other than what Mr. Ortega has already articulated?
Nothing to add, Your Honor. Thank you.
Okay, thank you. Mr. Elliott, anything you wanted to say in response?
Yes, Your Honor, I will, I think very briefly address it. This does not require medical judgment. The defendants actually represented in an almost identical case, the defendants in Shermer versus Williams. It was another medical transport case. Their application to the Supreme Court was denied, upholding the lower court's decision. And the lower court, and this is in the brief, so I won't go over it too much, but the Court of Appeals noted the exact argument that's being made here, that they were claiming that the medical condition somehow affected the way that this person was unloaded from an ambulance on a stretcher. Just like it didn't unlatch here, just like the step did not go down on the ambulance in this one, causing the one defendant to come around, the latch supposedly did not latch, and they did not have two people holding the cot in the Shermer case. In that case, the plaintiff actually did have medical conditions that were relevant. He did have IV bags. He did have things going on and had to be monitored on the transfer. But still, it was found nothing in the actual manner of moving them, the individual implicated medical judgment. That's exactly what we have here. Your Honor, you had the benefit of the motion where all of the testimony was cited. Michael Brendelhorn, the supervisor, indicated these cots are made for lay people to utilize. They're made for use with just little placards for people that have no medical training to load, unload, move people on them. It has nothing to do with medical conditions. Not either of the individual defendants that were moving the EMT and the paramedic, Mr. Bryan and Mr. Miller, testified that my client's medical condition had anything to do with how he was moving and being moved. In fact, they said this was just a pick up and go. They had one sheet. They didn't look at that. They both said that he wasn't even listing to the right when they pulled him out. He was a bit during the turns while they were driving, but not at all when they pulled him out. There was a simple procedure that does not require expert testimony. It does not require medical training or medical judgment that had to be followed here. It can be taught to the jury through looking at the handle, the manual, the placards, or the testimony of these individuals that have all admitted to their negligence. The facts have not changed since Your Honor denied this almost identical motion June 3 years ago, June 2022, I believe, when in reply to our first response to their motion for governmental immunity, they then also argued that it was medical malpractice. The facts have not changed. If anything, the position has been solidified. I've addressed the differences between the cases relied upon by the defendants, that all are nursing care cases requiring very specific medical knowledge, talking about amputees, talking about reading tests, talking about knowing the level of mental cognitive decline. No testimony here has revealed that any of that judgment was needed to determine how to take my client out of an ambulance on a cot and move him a few feet over to a facility without dropping him, without tipping him over, without driving the wheel into a ditch. The defendants have testified to all different things that allegedly caused this fall to happen. But they had control of my client. They did not operate that cot in the manner they were supposed to do so. They were negligent in allowing the cot to drive into this hole in the ground, almost identical to the Shermer case that the defendants are well aware of, and again represented the defendants in that case on the identical issue. So I'd ask you to deny the defendant's motion in its entirety, Your Honor, and allow this case to proceed on the negligence exception to the hospital exception to government immunity.
All right, thank you. Mr. Arteev or Ms. Beach, anything that you wanted to argue in response?
Yeah, just briefly, Your Honor, I think reliance on the Shermer case, first off, it's an unpublished opinion. It's not binding on this court. Second, it's plaintiff's counsels pointed out, our firm represented the EMTs and ambulance providers in the Shermer case as well. But I will note that, and we note this in our briefing as well, because we anticipated, them bringing this up, but basically there was a very fact-specific exception carved out in the opinion of the Shermer case. We cited to that in our briefing, where the Court of Appeals basically said that unlike this case, the issue really was a mechanical issue with the way the cot was supposed to latch onto the ambulance while the patient was being unloaded, and that was really the cause of the fall at issue. At least it seemed like from the allegations there, and based on the fact that Mr. Shermer's or the plaintiff's in that case medical condition, which was a heart attack, the reason why he was being transported, had no impact on how he was supposed to be unloaded from the stretcher, or the reason why he ultimately fell. That was the reason why the court said that this was ordinary negligence, not medical malpractice. And that's, again, as I've pointed out, I think it's quite different from what we have here, where we have a stroke patient. Again, there's ample testimony talking about how his condition was supposed to be considered while he was being unloaded from the stretcher, and specifically, his weight, the fact that he was paralyzed in the right, he wasn't able to communicate. The other thing I would like to point out, Your Honor, too, is that there are allegations and quite a bit of discussion in the testimony about subsequent actions by the defendants that should have been taken, which do implement, I don't think it's really much in dispute, but they do implement medical judgment. Specifically, there were questions about whether potentially the defendants were negligent in how they got Mr. Nellis back up. They should have used a backboard. In our clients explained in their testimony why that was not a good idea, or why their training indicated otherwise. And there are specific allegations in the complaint against the defendants, specifically noting that there was a failure to recognize potential injuries in Mr. Nellis, and that in I think paragraph 46 of their complaint does specifically say that they were negligent in failing to transport him to the emergency department rather than continuing him on to the long-term care facility. So I think those additional things do solidify further that there was medical judgment being at issue in this ordinary negligence or labeled an ordinary negligence claim. But correct, Your Honor. And the only other thing I'll add is I don't think it really matters whether it's a nurse or an EMT or a paramedic. The bottom line is, there's binding case law, I think, that indicates, bless you, there's binding case law that does indicate that the transport of patients in the medical setting does implement medical judgment. And I think in this case, as we've already pointed out in our briefing, that was certainly implemented in this case by the defendants. So thank you.
All right, Ms. Beach, anything that you wanted to add?
No, Your Honor. Thank you.
Okay, thank you. Again, I did read through all the briefs and the supporting documentation, as well as the law cited by the parties. The arguments of counsel here today and the record have been largely consistent with their arguments in writing. First of all, addressing the standard of review, the motion was brought pursuant to MCR 2.116C7, based on an argument that this is a claim that sounds in medical malpractice and therefore should be barred as an ordinary negligence claim. The court reviews those kind of motions based on the pleadings, and the court looks at all the facts and pleadings in the light most favorable to the non-moving party. And I think there's also, and I understand why counsel brought it also under C10, because I think, the court does need to conduct some sort of a factual determination as to whether there's a question of fact here about the elements of medical malpractice versus an ordinary negligence claim. So looking at it under those court rules, the parties have correctly cited kind of the analysis that the court has to make, which is two-pronged. Number one, did the incident occur within the course of a professional relationship? In other words, was there a contractual duty by the defendants to render professional healthcare services to the plaintiff? And then number two, do the claims raise questions of medical judgment that go beyond the realm of common knowledge or experience? And I really think it is that second prong here, as counsel have acknowledged, that that's the issue or the question in this case. I did read the Rogalski case, the Wiley case. I did look at the Shermer case that was cited by the plaintiffs. And in my view, there are factual distinctions between the cases cited by the defendants and what we have factually here. The Rogalski case involved moving a patient from a wheelchair to an exam table as part of a medical examination. The Wiley case was moving from a toilet to a wheelchair. And in reading the facts in those cases, to me, there's a distinction, because in those cases, the individuals involved were engaged in medical care, whether that's testing, whether that's, the individuals in the hospital facility getting medical care, and the transfer is made as part of rendering that medical care or during the course of rendering that medical care. And that's really different than what we have in this case. There really wasn't any medical care being rendered to Mr. Nellis. This was strictly a transportation issue here, getting him from point A to point B. And obviously that's not going to occur by way of a normal conveyance. There needs to be an ambulance given his condition. And so that's why, the defendants were involved in this, but they weren't engaged in or in the course of rendering any kind of medical care to Mr. Nellis. And I think that's where we really have the difference here. They weren't doing anything that would require medical judgment. They were just transporting him from one place to the other. They were required to use ordinary care in doing that, but I don't think they had to exercise any kind of medical judgment beyond what would be the realm of common knowledge or experience for an EMT, and knowing how to properly operate a cot, procedures for getting somebody in and out of an ambulance. Again, while that may be being done in the, going in and out of medical facilities, beyond that, there isn't any actual medical care being rendered or medical judgment being employed. And I do find the Schirmer case to be persuasive. Of course, the court is not bound by that case, and I'm not relying on that case, but I do think it does illustrate the distinction between what we have here and what occurred in Schirmer versus what happened in Rogalski and in Filey. And, I agree with Mr. Arte. I have a close reading of the Schirmer case that there was like a mechanical issue, which is different here. This was more of a, an issue of the way that the EMTs, took Mr. Nellis out of the ambulance. It wasn't purely a mechanical fault. But I think it still illustrates the difference, which is the lack of rendering of any medical care, and whether that's a mechanical failure, the failure to recognize a mechanical failure, or properly use a device. I think all of that falls within that realm, again, of just transportation as opposed to using medical judgment. So again, here I don't find the defendants were exercising medical judgment, mechanical. They were simply engaged in the mechanical operation of the stretcher, the operation of an ambulance, and again, just literally transportation or movement, but not movement in the course of medical care or treatment, simply for the purposes of transportation. And while maybe during the course of this incident there was some medical judgment employed, again, it's not whether every single piece of the interaction here is medical malpractice or ordinary negligence. It's whether this claim sounds in negligence. And I think it clearly, in my view, under the law and the case law, sounds in negligence. It does not sound in malpractice. And so for those reasons, the court finds that the motion should be denied. I'm not going to rule on the issue of whether or not Munson could or couldn't join in. The court's denying the motion. I think it would be equally applicable to Munson or to the Kalkaska defendants. I don't think either is entitled to summary disposition because, again, regardless of who the defendants are, the facts of the case show that this sounds in ordinary negligence as opposed to malpractice. So the motion is denied as to all defendants. And Mr. Arteev and Ms. Beach, I would just request that you prepare an order reflecting the ruling of the court as to that issue and submit that under the 7-day rule. The second motion that we have up is defendant's motion for partial summary disposition regarding the damages related to stroke care and rehabilitation. As with the previous motion, I had an opportunity to review that as well. So, Mr. Arteev, any oral argument as to that?
Thank you, Your Honor. I think this motion is in part kind of related to the motion that was ruled upon in June. And I think some of the arguments that were made during that particular motion will kind of mirror what we argue here in this particular motion. So again, I'll try and keep it brief. But essentially, this particular motion is brought under C10, 2.116 C10. Basically, we're focusing in on a specific claim that is made by the defendants regarding the allegation that the fall at issue that Mr. Nell sustained somehow impacted Mr. Nellis' ability to either recover from his stroke or worsened his stroke symptoms. Basically, Your Honor, despite, making pretty complex medical claims against the defendants in this case about how stroke impacts a patient's recovery, functionality, and how fall specifically impacts that stroke, really, there hasn't been any admissible evidence in this case to support that particular allegation. We are at now the close of discovery. Plaintiffs can't just rest on mere allegations to support their claims. And specific to the C10 motion, the defendants in this case have affirmatively rebutted that allegation by offering the testimony of Dr. Gebel, a neurology expert who, as you may remember, Your Honor, the plaintiffs claimed that he was unqualified to speak on these issues, but the court denied that particular motion. And the treating neurosurgeon in this case, Dr. Raja, each of whom presented affirmative testimony based on their education, training, experience, indicating that Mr. Nellis' stroke was essentially so severe and the particular nature of the stroke that rehabilitation really wouldn't have mattered at all. In particular, they're basing that off of the type of stroke that Mr. Nellis sustained. It was a left ICA occlusion and left M1 occlusion, caused about 54 cc's of dead brain tissue in Mr. Nellis. That specifically affects his right extremity function and his speech function. And those are specifically the two areas where the plaintiffs claim that Mr. Nellis has his deficiency from the stroke. Again, Your Honor, the plaintiffs in this case, they essentially need to prove that the fall at issue was a proximate cause of Mr. Nellis' current day stroke deficits. They can't simply say that there was a possibility that the fall caused the stroke. That's simply not sufficient. They're judged on a more likely than not standard. And again, under the C10 motion, we've affirmatively rebutted that. They can't rest on their allegations, and there's really no testimony rebutting Dr. Gebel or Dr. Raja's testimony, specifically as to the fact that the type of stroke that Mr. Nellis sustained wouldn't allow him to recover those functions based on the nature and the imaging that they reviewed and the medical records. So, Your Honor, and then again, we point out that there's really not much evidence to suggest that plaintiffs' allegations are accurate or verifiable. They kind of rely on a couple of different arguments. The first argument was primarily that Dr. Gebel was not really a reliable expert. His opinions weren't reliable, but we've already disposed of that particular argument. The second one is that they're relying on the testimony of the occupational therapist, Rachel Dawson, in this case. But again, we point out in our reply brief specifically that her testimony does not create a genuine issue of fact in this case. First off, her background and experience doesn't make her qualified to rebut the evidence presented by a neurosurgeon or neurologist. She's an occupational therapist. She, I think she testified to about 15% of her patients being stroke patients. She's not a medical doctor. Her role is limited to rehabbing the upper extremities of a variety of different patients, not just stroke patients. Additionally, her testimony was really speculative. She couldn't really say with any level of specificity how Mr. Nellis' stroke recovery could have been better. She just generally says that in general, patients who receive stroke-related therapy in the first 3 months tend to get better, but she doesn't really acknowledge Mr. Nellis' particular case. And in fact, she acknowledges that in her deposition testimony. We cite that in our reply brief. Additionally, as co-defendants cite to, and we cite to in our reply brief, there's a recent Court of Appeals decision, the Infinity Physical Therapy case, that does indicate that a physical therapist is precluded from testifying on opinions related to causation. That's essentially the same thing that we have here in this case. We have an occupational therapist who has very similar kind of statutorily defined roles as a physical therapist, and basically her background excludes her from providing opinions on causation. Additionally, Your Honor, there's really no ability by any lay expert or lay witnesses in this case to create a genuine issue of fact to rebut the opinions of Dr. Gebel and Dr. Raja in this case. Again, it's all speculation. It's not founded on any sort of actual reliable knowledge in this case. So, Your Honor, essentially, we're asking these allegations to be prevented from being brought before a jury because essentially we've, I think, affirmatively disproven that specific area of plaintiff's complaint. Again, there has not been any evidence to suggest otherwise to create a genuine issue of fact. And with that, Your Honor, I'd ask that those particular allegations related to the stroke-related damages be stricken in this case. Thank you.
All right, thank you. Mr. Elliott?
Thank you. Your Honor, you'd like me to go before Ms. Beach?
Ms. Beach, did you join in this one too? I thought it was just the other one.
No, Your Honor, we did file a joinder and concurrence in this motion, and we talked primarily about the Infinity Physical Therapy opinion, which, as Brother Counsel mentioned, as a published opinion from the Court of Appeals, has not been appealed to the Supreme Court. And it says that under MRE 702, if your statutorily defined scope of practice does not include diagnosing medical conditions, then you are not qualified to testify as to causation of those conditions. So I will reserve further commentary for after plaintiff counsel speaks. I don't have anything to add substantively at this point.
Okay, thank you. Mr. Elliott.
Thank you, Your Honor. Your Honor, I agree with Mr. Artev. This is related to the motion to strike Dr. Gebel. You've already heard much of the arguments, and I know you've read the brief, so I will be brief. At the end of that hearing, though, while you did not strike Dr. Gebel, you acknowledged that, I wrote it down, damages caused by delay in stroke recovery rehab are fertile ground for cross-examination. That's what we do have here. It's not as complicated as it's, being alleged by the defense. The delay in stroke rehab, it's not disputed that he was delayed. It's not disputed that he was ordered to undergo physical therapy. I will address this again when I talk about Infinity, because, Your Honor, that I did not address in my brief because it only came through on the reply. I will clearly address that case. But Dr. Raja acknowledged my client was ordered to physical therapy. It's not like Infinity where the physical therapist was saying some underlying cause made him need physical therapy, some medical diagnosis. Ms. Dawson's testimony here is as a treater. She's not testifying as an expert saying he needed therapy because of what happened. She's testifying as someone who treats people, who has treated this man for years, and says that based on his level of support, what she sees with his family, all of her medical education and training, actually doing rehabilitation work, he would have been in a better position if he had not had that delay. The delay was caused by the fall. There's no dispute in that. No one is disputing that. The fall caused the delay. The delay is issue. The delay in therapy, and we have a therapist here saying that delay caused a problem. We also specifically have her saying even when she was doing therapy on him 6 months later, he was still wincing in pain from the pain in his broken ribs. These are facts. These are facts she can tell to a jury, that a jury can decide, and that can go against Dr. Gebel. We also have Dr. Raja. I understand the defense wants to blow past and not address all of his testimony, but he acknowledged that even a month delay would have been significant, and that no one knows where Mr. Nellis really would have been if he had not been delayed. He also acknowledges that he's had many patients with the same double strokes, double vein strokes like Mr. Nellis has, walking independently and doing much better than Mr. Nellis is. Dr. Gebel himself acknowledged that the period right after a stroke is the best time to get therapy. He acknowledged that to delay someone to even test his theory would be unethical because you would never intentionally cause someone to delay. These are issues that all three doctors, or all two doctors and Ms. Dawson, can testify to, that it makes it a question of fact for a jury as to what damages were caused to Mr. Nellis by this delay in post-stroke therapy. If the jury determines that the fall caused this delay, as has been acknowledged already, so I don't dispute that, I don't believe they will not determine that, they get to decide, was there an ultimate, what's the damage caused by that, basically? Was there a deficit? If they cannot determine exactly how much that is, it is why I referenced jury instruction 50.01. The defense in their response cites to a Beetle case regarding that. The Beetle case found that that instruction should have been given. Not that it shouldn't have, just that there was no harm in I believe it was called the Beetle case. We have a clear question of fact, I believe, as to what harm was created here. If the jury cannot determine how much, they are going to have to be given that instruction. I think appropriately should be given that instruction. When I go back to infinity now, which I'd like to address, first, this right in footnote 2, they acknowledge this was before the rules of evidence they're applying this to were before the rules of evidence were changed to adopt the federal Daubert standard, which we are dealing with now, as was extensively discussed at the prior hearing. That's footnote 2 of infinity. Second, again, I'd like to point out the therapist in infinity was a therapist testifying as to some medical cause for the client even needing physical therapy, and they said that's not appropriate. That's not what Ms. Dawson is testifying to. Her testimony goes to exactly her job as a therapist for this specific patient. She is a treating doctor, much like the doctor in the case, I think McCluskey. Yeah, McConkey, the McConkey case that the defense cited. In that one, there was a treating doctor that they acknowledged if the actual treater had seen the client, that could have been admissible, but in that case, the treater hadn't even seen the client. Here we have Ms. Dawson testifying about her treatment of a specific person, knowing his support group, knowing how hard he works, knowing where he came in, knowing everything else about him, and testifying only to therapy. And her experience with that, I think it's clearly can come in. I think it's a question of fact for the jury, and they can wait whether they want to believe, the hired expert, or they want to believe Mr. Nellis' actual treating physicians and therapists. I'd ask you to deny this partial motion for summary disposition and allow us to get the case to the jury.
Thank you. Mr. Arteaga?
Thank you, Your Honor. I think one of the first things we want to point out is that we're not saying that Ms. Dawson can't testify as to her own experiences in treating Mr. Nellis. Problem with Ms. Dawson's testimony is she doesn't say anything or acknowledge the fact or the testimony by Dr. Gebel or Dr. Raja, which does indicate that basically in Mr. Nellis' specific situation, the way his stroke came out and the nature of his stroke basically indicated that he would be permanently disabled. And I don't think there's really much dispute in that. Miss Dawson acknowledged that really she only started treating Mr. Nellis 7 months after the fall at issue. So she really can't speak to his condition before and after the fall. So if we're saying, she's a treating physician who's going to talk about her own basis and experience, she really doesn't have any personal knowledge as to how the fall actually affected. She can guess, she can speculate, but ultimately she doesn't provide any sort of testimony that directly addresses Mr. Nellis' specific issue. or deals with the testimony of Dr. Gebel or Dr. Raja with the testimony about the true core infarct. Additionally, Your Honor, we're also not disputing that she can talk about pain or discomfort that Mr. Nellis had during the treatment. The problem is that there's still a disconnect between how that impacted his stroke recovery, or whether the defendants in this case were liable for the stroke-related damages specifically. And I guess, Your Honor, we keep hearing from plaintiff's counsel is that nobody knows. But ultimately, Your Honor, that tells me that this is, again, still a speculative situation, or a speculative argument that plaintiffs are making as to the stroke-related damages. Again, they need to prove on a more likely than not standard that more likely than not the fall at issue here was the proximate cause of Mr. Nellis' current day stroke deficiencies. And we have overwhelming testimony that's really gone unrebutted that's saying really his current day deficits and that he's currently experiencing are related to the stroke. And I don't see quite any admissible evidence, at least, that indicates that it was the fall at issue that created those current day injuries. So with that, Your Honor, I think there's more than enough evidence to strike these particular damages in this case. Thank you.
Thank you, Ms. Beach.
Thank you, Judge. I'll be brief. Ms. Dawson's testimony is a causation opinion. As Mr. Elliott said, the jury will be using her testimony to decide what damages were caused by the delay in treatment. So if she's giving testimony on causation, she has to be qualified to do that under MRE 702, and the Infinity Physical Therapy case says that she is not. Now, MRE 702 was amended after the care at issue in Infinity Physical Therapy, but what Brother Counsel apparently doesn't know is that it was amended to be even more strict in its burden of proof for the party who is promoting the expert testimony. So now MRE 702 matches FRE 702, which was also amended, and it says that the proponent of the expert testimony has to more likely than not establish that it's reliable under the factors in that rule of evidence. So it was a silent burden before. Now it's a more likely than not burden. So actually, the burden of proof has gotten worse for plaintiff under MRE 702 than it was even in Infinity Physical Therapy. So for that reason, I don't see any way of getting Ms. Dawson's causation opinions into this case, which plaintiff needs to prove that the alleged delay in treatment was a factual cause of the plaintiff's current deficits. And for that reason, I think the motion should be granted. Thank you.
All right, thank you. Again, I did read through the motions. I read through the testimony of Dr. Gebel again, Ms. Dawson and Dr. Raja as part of my preparation for the motion. This is a motion brought under 2.116C10, which tests the factual sufficiency of the plaintiff's claim for damages here in this particular issue related to the delay in his treatment for stroke. The moving party must come forward with depositions, admissions, or other evidence showing that there is no question of fact that the plaintiffs can't meet their burden of causation there. The court has to view all the facts in a light most favorable to the plaintiffs in this case. Once the defendants make their showing, then the plaintiffs have to counter with testimony or other evidence that would show that there is a question of fact. I think the biggest thing that I took away from this, and Mr. Elliott, I think, correctly stated what I thought as part of the motion regarding Dr. Gebel. And I think it informs kind of the way that I'm ruling on the motion as a whole, is reading the testimony of all of these individuals, I think neither the plaintiffs nor the defendants can establish that there's no question of fact here. The big takeaway for me in reading the deposition testimony of all of these professionals is that number one, recovery from stroke is highly individualized, that it depends on a number of different factors that may be applicable to one individual but not another. That individuals facing similar or the same circumstances in terms of the severity of the stroke, the area of the stroke, the treatment after the stroke may have very different outcomes based on their own individual characteristics. And that it's impossible for anyone to really predict the degree to which a person is going to recover from a stroke, even under optimum conditions. What I think really makes the difference to me in reading this is that they all, I think, were consistent in their opinions that the earlier that a stroke is treated, the better the recovery is going to be. The sooner that somebody has interventions, the less other complications or comorbidities or other factors involved, the more likely it is that a person's going to have a better recovery. All of those things come into play when trying to determine to what degree someone's going to recover from a particular stroke. And they were all consistent in their testimony that a delay is going to have a negative effect on the ability of the person to recover from a stroke. And again, I mean, to put it in my own words, I think that all of them had the opinion that this accident certainly didn't help. I think they all had difficulty in testifying in terms of how much better Mr. Nellis would have been if not for that. But I think they were all, again, pretty consistent in my own words in opining that the accident certainly didn't help his recovery from the stroke. And again, looking at this under a C10 standard, I don't think that the defendants have established, based on the testimony of Dr. Gebel or Dr. Raja, that there's no question of fact that the delay had no effect on Mr. Nellis' recovery from the stroke. The flip side of that coin is I don't think the plaintiffs can show, that there's no question of fact that he would have had a better outcome. And so to me, again, this is something that really needs to go to the jury. Both sides present their evidence, and a jury decides to what extent they think that the delay in Mr. Nellis' treatment resulted in additional damages to him because it negatively impacted his ability to recover from that stroke. So for those reasons, the court finds that there are questions of fact, and the defendant's motion should be denied. In terms of the degree to which and what exact testimony of Ms. Dawson may be admissible or not admissible, again, I'm looking at this motion under a C10 standard. This wasn't a motion to exclude her testimony to the extent that the defendants feel that there's a basis to exclude any opinions by Ms. Dawson based on MRE 702 or 703. Then that would have to be the subject of a separate motion, because I think that's a different standard that would need to be applied. But in terms of this motion under a C10 standard, the court finds that there is a sufficient question of fact to allow that to go to the jury. So the court will deny that motion, and Mr. Arteev and Ms. Beach, I would ask that you prepare an order reflecting that ruling of the court and submit that under the 7-day rule. I also want to address, because I forgot to do it as part of the ruling on the previous motion regarding the defendant Aylesworth. Obviously, the court has made the rulings that it's made and excluded the claims that it has made. When I saw that, I went back over the testimony, the deposition testimony of Aylesworth, Michael Bryan, Yale Miller, and in my view, it's not simply a housekeeping matter. I think certainly any claims that the court has dismissed that would apply to Aylesworth certainly could not be argued by the plaintiff because the court has dismissed those claims. But in terms of ordinary negligence of Aylesworth, I think there is still room for the plaintiffs to argue that there was ordinary negligence on the part of Aylesworth. Obviously, again, to the extent that the plaintiffs would try to argue that that's connected to one of the claims that has been dismissed, I don't think they can bootstrap a dismissed claim or try to revive a dismissed claim by calling it ordinary negligence. But in my review, I think under a motion for summary disposition standpoint, I think there's a sufficient question of fact as to whether there was negligence on the part of Aylesworth that would preclude his dismissal as to the remaining claims. So the court is going to deny that motion as well. So Mr. Arteaga and Ms. Beach, if you can include that in your order as well. And I think that concludes our matters for the day. I do have another hearing coming up at 3, so all parties on this file are free to disconnect at this time. Is there any last minute things that we need to
Your Honor, we did have a status conference set for today because I think the only thing left is to set this for trial, get any final orders from the court.
Okay. All right. Let's see. One second. I should just assume that I have a status conference set all the time. Okay, in terms of scheduling going forward, Mr. Elliott, what would you like to request here? I know you just indicated you'd like the court to get this set with some trial dates on the calendar.
That's what we're ready for. Your Honor, this has been going on since 2021. There's been extensive briefing. You've ruled on all of the motions. We're thinking plaintiff side of the case is going to probably take 3.5 days for our proofs. Go to Mr. Artev or Ms. Beach for the defense side. But I'd like to get on the docket and get this thing scheduled. I think last time you indicated we were one of the oldest civil cases. So I'd like to get the earliest date that we can.
Sure. Okay. Remind me again, what I'm assuming the parties have gone through mediation on this. What was there one mediation?
We went through a facilitation. We were nowhere even close. My understanding is the defense, even long before we tried to facilitate, we discussed numbers and it doesn't seem like that's going to work. I think this is really one that needs to go to the jury. As Your Honor said, there's a lot of variables out there. And if the defense wants to reach out, we don't need a mediator at this point. We've already been through that, spent quite a deal of time on it with briefing and everything else.
All right, even since some of the rulings that have narrowed the claims and.
Yes, Your Honor. The only thing left was this basically Munson's position was we're going to be out of it. And this was before you denied their motion on that. But Kalkaska, they had these arguments they made, but no, it was well after Your Honor already limited it to negligence after we had, and had time to do depositions, and we engaged in more discovery after. But I think we need to get to the trial.
All right. So how far out, Mr. Elliott, do you want the court to set this?
I'd like it set as soon as possible. My client is getting older, Your Honor. I want him to be hopefully alive still when this is heard. I'd like it as soon as possible.
Okay. All right. Mr. Arteav?
That's fine, Your Honor. I understand that plaintiff's counsel wants to set this for trial. I'm not, opposed to that. I will say, I think, some of these rulings, obviously we can continue to discuss. It doesn't sound like plaintiff's counsel is interested in facilitating this case any longer with the private mediator, at least. So that's fine. But obviously, the court can set it for whatever date is convenient for it. Obviously, we will have to look at our trial calendar as well. We do have several trials already scheduled. I think pretty much every month for the remainder of the year. But we can obviously double check that. And I know there's some rules on like priority and things like that. So we can address that once the court, I think, has come up with its own trial schedule. The only thing I guess I would ask for, I think there are, I don't think this court ever set like deadlines for motions. I could be wrong, for like motions in limine, and kind of pre-trial things like disclosing witnesses and things like that. So if the court does set this case for trial, I guess I would request, specific deadlines for those as well.
In your honor, James
Okay.
Elliott, if I may have some input here. I believe you have already set dates. We've already exchanged witnesses a number of times. So we have that done. We are looking at an early trial date. Again, Mr. Nellis is getting close to 80 years of age. He did have the stroke. 6 weeks for us would be more than enough. Everything's done. I mean, everyone's been deposed. We have the transcripts. We're virtually ready to go. And if the court has the time, we would love to get in at the earliest possible date based upon
Okay.
the age of the case, which is, I mean, it's 4.5 years. It's
Okay.
when it happened. The case has been filed close to 4 years.
Okay. Ms. Beach?
Thank you, Judge. I am not trial counsel. I do have Mr. Dwayhe's trial calendar pulled up in front of me, and as always, it is chock full. But I can respond as to his availability on any particular date at the moment, as I have knowledge of it.
Okay. Defendants, how many days do you think we're going to need for your side?
I would anticipate at this point probably two days, Your Honor. So I would think this trial would probably just take a full week in the court's time. So
Ms. Beach, what are your thoughts on that?
I don't have any. Again, I'm not trial counsel. I don't try cases, so I will defer to Mr. Artea's assessment of how long the defense case will take.
All right, Mr. Elliott, do you think we can get the whole thing done in 5 days?
I would think so. I would think so.
Okay. And that makes a big difference because I'm in a different county. I have a 3-county circuit, so I have week blocks in each county. So if we can get this in 5 days, I could schedule this a lot quicker. Otherwise, if I have to, take time away from one of the other counties, then I got to juggle time with the other circuit judge, and it gets more complicated and more difficult to find a date. So,
Your Honor,
I
could
will
you
set
tell us
this-
your trial days as far as the time? I mean, are they full days?
Yes, I go full days. Like if we have this set for a 5-day trial, we would start Monday morning at 8:30 with jury selection, and then just go constant until we're done with the case. So I don't do like jury selection on one day and then we come back like a week later, and we jury selection right into opening statements and proofs, and then I do full trial days, 9 a.m. to 4:30, 5 o'clock.
I would think a week would be more than enough time. Because we've
Okay.
narrowed everything down. We know who everyone is.
I mean, I feel like from what I know of the case, and I feel like a week would be enough time.
Yes.
Even with selection. So, okay. So I'll set this for a 5-day jury trial. I don't know, as I'm sitting here in Kalkaska, what my trial weeks or schedule here looks like. I can tell you just anecdotally, I don't think my criminal docket trials are backed up, and those have priority. So I think, within the next, I guess I don't want to say anything without looking at it. I don't want to make promises I can't keep, but this is, I'm going to get it set for the soonest possible trial date. I get plaintiffs need to move forward. It's totally understandable, given Mr. Nellis's age and condition. So I will do my best to get it scheduled as quickly as possible. What I do and what I'm going to put in the scheduling order today, along with the trial dates, is about 30 days prior to the trial date, we will have what I call a trial preparation conference. That date would be the cutoff for motions in limine. So in other words, you guys can file them and notice them up anytime you want, but they would need to be filed and noticed for hearing no later than the date of that trial preparation conference. All the parties should submit and exchange final witness and exhibit lists prior to that trial preparation conference. And again, I'll put this all in the order so that you all have it. And then at that trial prep conference, if there are motions in limine, we'll hear those and address those. The parties will be aware at that time of each side's witnesses and exhibits. At that point, we can talk about whether or not there are going to be any stipulated exhibits, whether you each want to put together binders of exhibits for jurors and witnesses in the court, and how that's going to work. We'll address jury instructions at that point. We'll address, the composition of the jury, how many jurors we want to sit and how many we want to have compose a verdict. We could talk about, what counsel's going to need in terms of the courtroom, video technology, that kind of thing. And address all those issues so that when we get to the morning of trial, it's a matter of everybody just going on the record and starting to pick a jury. So that's kind of all the things and we'll address that. Like I said, 30 days prior to the trial, it should give everybody plenty of time to be ready to go. So what will go out from today is a status conference order reflecting what I've just discussed, a date for that final trial prep conference, and then the trial dates.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Okay. Mr. Elliott, anything else I can address for plaintiffs today?
No, thank you, Your Honor.
Done, Your Honor.
Ms. Beach?
Nothing else, Your Honor. Thank you.
Okay, Mr. Arteyev?
Nothing on my end. Thank you, Your Honor.
Okay, thank you. That's all for today, and all parties are free to disconnect at this time.
Thank you.
Thanks.
Let's see, both the 345s. I get a bunch of names here.
I think there are 3 now at 345. Let me just make sure I'm not giving one. New one. Make sure I'm not giving you the wrong stuff.
This is the new one.
Yes. Ingram phone. Thompson.
Okay.
Oh, that's right. Goodness.
Okay, let's go on the record in, let's see. Cynthia Ingram versus Dusty LaFond, that's file number 2514741. If I could have both counsel put your appearances on, starting with plaintiff, please.
Justin Cole, Your Honor, for the plaintiff.
Good afternoon, Your Honor. Miran Alays here for the defendants.
Okay, we're on the record today for purposes of a scheduling conference in this case. Mr. Cole, can you just tell me a little bit about your case here and then just what you'd like to see for scheduling as we get started?
Sure, Your Honor. Thank you. It's an auto negligence case. The accident occurred on September 27 of 2024. The allegations are that Mr. LaFond was negligent as he was traveling northbound on US 131, was unable to slow down for some traffic, collided with the vehicle in front of him, then swerved over into the center lane, striking my client's vehicle. The injuries very generally, Your Honor, involve the left hand and wrist with a torn tendon, and then some fractured fingers on the right hand where we had some surgery and hardware. As for discovery, I do believe we have the plaintiff's, my client's deposition scheduled for September 3, it looks like. So we're moving along there. I believe disclosures have been exchanged. As far as timing for discovery, Your Honor, I just know how slammed everybody seems to be, and co-counsel can jump in if he disagrees, but I always just request kind of a standard 180 days. That way we're not coming back all the time, wasting your time asking for extensions and things like that.
Okay, Mr. Elias, do you have any objection to that time frame for discovery?
No, Your Honor, not much objection and not much else to add, really. We're getting going on discovery here and getting some depths in. We're going to probably need some time to possibly for IMEs or whatnot. So I believe 180 is fair.
Okay, all right. So we'll go with 180 days for discovery. Any objection to having facilitated mediation within that period of time, Mr. Cole?
Oh, absolutely. Oh, well, I should say no objection, of course. Yeah, no, that came out wrong.
Mr. Elias, any objection to that, Mr. Elias?
No objection at all, Your Honor.
Do you guys think that you'll be able to agree on a mediator?
I'm sure we can.
Yeah, I don't see why not.
Okay. So in the my standard pretrial order, it just has the parties to requires the two of you to confer to attempt to reach an agreement on a mediator and then notify the court in writing. If you can't agree, then there's a process for selecting one. Mr. Cole, do you have everybody in that you think you need to have in? Do you need to amend pleadings at all at this point?
No, Your Honor, I think the pleadings are satisfactory.
Okay, Mr. Elias?
Nothing on my end, Your Honor.
Okay. Do either of you have any objection to dispositive motion cut off 30 days following the close of discovery?
No objection from the plaintiff.
No objection either from the defendant.
Okay. And then what I typically do is set a status conference either at the close of discovery or at the time of a dispositive motion, if any have been filed, and kind of check in with the parties and see where we're at, and then schedule further from there. Mr. Cole, are there any other dates that I can address for your side today?
No, Your Honor, I think we're all set.
Okay, Mr. Elias, any other dates I can address for your side?
Nope, nothing, Your Honor. Is the court going to send out a scheduling order?
Yes, I put everything we've discussed today into order that'll go out to both of you. And then also the court will send out notice of the date and time for that status conference in about 6 months.
Okay, thank
Sounds
you.
good.
Okay, thank you. That's all I have. You're both free to disconnect.
Thank you, Your Honor.
Thank you. Good afternoon.
Mr. Elias, I'll send you just a quick email right now about mediator suggestions, just so I don't lose track of it.
That sounds good.
All right. Thanks a lot, Your Honor. Thank you.
Bye-bye.
Bye.
Thank you. Okay, let's see here. Ma'am, is your name Bonnie Mae Regal?
Yes, Your Honor.
Am I pronouncing that correctly?
Yes.
Okay, and sir, you're Tyson Thompson, is that correct?
Yes, Your Honor.
Okay, we're on the record in Regal versus Thompson. This is file number 25-14773. The record should reflect both parties are present today by Zoom video. This is a first hearing on this divorce matter. At this hearing, I try to determine what kind of proceedings we're going to need to finalize the divorce in this case. And so my first question, Ms. Regal, have you had any discussions with Mr. Thompson? And have you reached any agreements about dividing up assets or debts?
Yes, Your Honor. We're both in agreement of how we're going to divide our assets.
Okay, so from your standpoint, is there anything in dispute that the court would need to decide?
No, we have decided that the house will be going to me, that I'll be selling Tyson's car and then giving him the money, sending him back his things. But other than that, Your Honor, there's nothing else I can think of.
Okay, Mr. Thompson, were you able to hear that?
Yes, Your Honor.
Do you agree with what Ms. Regal's had to say?
I do agree with what Ms. Regal has to say. We have mutually drafted and reviewed a marital settlement agreement that reflects everything we've agreed upon, including the division of property and personal belongings. We plan to sign the document together today during the Zoom hearing so it can be witnessed and included as part of the official record.
Okay, so you're saying you want to do that during the court proceeding?
Yes, Your Honor.
Okay. All right. That's not really something that we need to do on the record here. You guys can do that on your own, as long as both your signatures are on it. And because there is nothing in dispute and you guys have agreed on everything, I can set this for a final hearing date. And that'll be by Zoom, just like we're doing today. The court will send you both a notice of the date and time of that hearing. There, along with that settlement, which you should submit to the court, to the clerk's office here once you both signed it. There's also another document called a judgment of divorce. That is the final form that the court needs to sign in order to finalize the divorce. So, Ms. Regal, you may have that already, or you can get that in the same place where you got your other forms to file for divorce. But that'll need to be filled out and signed by both of you and then submitted to the court prior to that final hearing. That final hearing is going to be in about 30 days, so you've got a little bit of time to take care of that. Ms. Regal, do you have any questions about that?
No, I do not, Your Honor.
Mr. Thompson, do you have any questions?
No, I do not, Your Honor.
Okay, that's all I have for this hearing today, and you're both free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
You still have one more Zoom?
I think it's gonna be in person.
The personal protection?
Yeah.
Yeah.
Let me just finish this one up and then we can bring them in. Okay. Mr. Carey, are you able to hear me okay?
I am.
Okay, we'll go on the record in Martin versus Elliott. This is file number 2514691. The record should reflect Mr. Carey's present today by video on behalf of plaintiff. Mr. Carey, this is your motion for entry of a default judgment, is that correct?
Yes, sir.
Was there anything that you wanted to, go ahead.
I'm sorry. We represent the plaintiff, Andrew Martin, bringing this action to quiet title against Kevin L. Elliott and others that may have title subordinate to his. In this particular matter, we attempted personal service. We failed. We asked for alternate service. Court gave us that order. We complied with the terms of alternate service to provide notice to Mr. Elliott and his assigns. We've not received an answer of any kind from anyone, and we move to quiet title, and I'm hopeful that the court has in its file the proposed default judgment quieting title.
I do have that. I reviewed the file. It does appear that the defendants were properly served with alternate service in this case upon motion and order. This was hearing was set for 3:45 today. It's now 4:02. No one has appeared either virtually or in person to contest the entry of the judgment. So I've signed that judgment with today's date. Anything further that I can address, Mr. Carey?
No, thank you, Your Honor, for allowing me to appear via Zoom, and have a great day.
Okay, thank you, and you're free to disconnect.
Thank you.